Good morning. Somebody online requested a sound check. Can everybody that is remoting in hear?
Check, check.
Check, check.
Okay, Mr. Harwood, are you attending remotely? And can you let us know if you can hear?
He's muted. Is he muted?
Let's see, no, he's unmuted.
Okay, can anybody hear me?
Yes, we can hear you.
Okay. Thank you, whoever said that. I'm paranoid about the technology, especially I'm on the East Coast now in Maine, and the internet here is about as bad as it gets anywhere.
Apologize for the delay and the reverb. Good morning, everyone. We can go ahead and get started. Let me just pull up the agenda. Sheila, do you have an extra copy of the agenda, printed agenda handy?
I do.
Thank you. Good morning, everyone. Apologies for the late start, but it's the June 20th, 2024 meeting of the Oil Conservation Commission. We're going to go ahead and get started. I'm going to do a roll call. Dr. Mpoma. Present. Commissioner Bloom.
Present.
Let the record reflect that a roll call, that a quorum of the Oil Conservation Commission is present with all commissioners present. A quick note about my availability today. I had a medical dental issue come up, so I have a hard stop today at 1, but if things are proceeding, there will still be a quorum of the commission as necessary. I just wanted to flag my availability. The agenda for today's meeting was distributed in advance. Looking at my fellow commissioners, do you have any edits or additions to that agenda?
No, Mr. Chair.
Can I get a motion to approve?
I so move.
I second.
Let the record reflect the agenda for the June 20th, 2024 meeting was unanimously approved. The OCC clerk also distributed a copy of the meeting minutes from the May 9th, 2024 meeting. Have my fellow commissioners had a chance to review, and do they have any edits?
Yes, was able to review and no edits.
Can I get a motion?
I so move.
Second.
Let the record reflect that the minutes from the May 9th, 2024 meeting were unanimously approved. And now we move on to our consolidated cases, which have been on the docket for a bit. And I am going to turn it over to Commission Counsel for a moment to do some observations, and maybe we'll have a little discussion about how to walk through the various motions. I think as Mr. Rubin will explain, there are some overlapping issues, and we want to do it in an efficient and orderly manner as we work through the motions. But with that, I'll turn it over to Commission Counsel Rubin.
Thank you, Mr. Chair, members of the commission. Having read the motions to regarding the scope as well as the motions to dismiss, my recommendation in doing this in an orderly and efficient manner, it is apparent to me that the substantive issues, I think, in the motion to dismiss, if we could resolve those today, those are certainly fully briefed. I have a few observations about that I think would probably allow council to be more focused in their comments rather than simply going through their whole presentation and about the, going through the whole history of the case. We've read that. So my suggestion is that we deal with the motions to dismiss, the motions regarding scope, are a little more complicated, but I believe they may shake out after the motion to dismiss is decided. And then we have, as a third matter, the motion to reconsider the discovery order, which again, discovery comes last after the substance, but I have separate comments on that to advise the commission. And as always, we do have the option of going into closed session to deliberate anything at any time on these pending adjudicatory matters. I know that it's not the commission's practice to do so, but just as a reminder, it doesn't need to be on the agenda for us to do that if you feel like you want to talk to me or ask me advice in confidence in a privileged manner. So with that, Mr. Chair, if I may, just dive into what I've observed are the issues as I see it on the motions to dismiss.
Mr. Rubin, I'm sorry. What were the three items you mentioned today? Looking at motions to dismiss, discovery order, and I think I missed one in the middle.
There are separate motions as to the scope of the hearing that was consolidated. There are a lot of at least nominally moving parts with other applications that are either before the director still or otherwise not in this agenda. And those, I think they all fundamentally relate to the issue in the motion to dismiss, which is what to do about the San Andreas unit under the Unitization Act. So those are the three: motion to dismiss, motion for scope, and the discovery order. So if I may, and this is directed, of course, to council as well, Mr. Rankin and Ms. Harvey. It's my observation that the Unitization Act certainly does not preclude the commission from amending its prior order defining the MSU if there was proper good cause to do so. And certainly the relief being suggested by Goodnight, if not part of a request to amend to change the scope of the unit, specifically with respect to the San Andreas, it wouldn't have been proper. But they have couched it properly as whether or not the San Andreas, which as far as we know, is where produced water is being injected. We do not, the facts seem to reflect that it has long been used as a produced water disposal unit, disposal zone. No hydrocarbons have been pulled from it to date. I don't believe that's in any dispute. There might be some issues to whether some could be. But I think as a matter of standing, that was one issue raised in the pleadings, and as a matter of whether or not Goodnight has a property interest, the right to inject produced water certainly does not require a state engineer license. That does not appear to be the proper inquiry, though. As an aside, it's a water right is not a property interest anyway. It's a usufructuary right. But regardless, the property right that is being asserted here is the right to inject produced water, which is a valuable right, a valuable privilege or a contract right. There is evidence before the commission. There doesn't need to be any dispute that they have contracts in place that would allow the injection of produced water into the San Andreas if it was not part of this, if it was otherwise allowed by either those members of the unit who would not dispute it, or if it was not part of the unit. And it certainly is a financially valuable issue. Otherwise, we would not be here today. So I do believe that there is standing asserted based on the undisputed facts before the commission, that Goodnight has a dog in this fight. So this comes down to whether, now the procedural posture again, and this is important to keep in mind, this is a motion to dismiss. And in a motion to dismiss, we will generally look to the rules of civil procedure to guide us. It's whether there are any issues of fact that would preclude a decision based upon what has been asserted just by the lawyers. And it does appear to me today that there is a concern, there is perhaps a fact issue that the San Andreas should not have been or was erroneously included in the original definition of the EMSU. And it is my advice to the commission that if that decision was either made in error or for whatever reason new information has come to light, that would indicate that the commission needs to revisit that position. It certainly should do so. The notion that you cannot correct prior mistakes as a governmental entity, there's no support in the law for that. You just have to have the right parties there. So, and I'm saying this because I'd like to hear from counsel, particularly from Empire, as to whether or if what the issue is with, if there is produced water, if the San Andreas meets the definition of a pool insofar as it has some accumulation of crude petroleum, oil, or natural gas, or both. And if we could go back in time to when this matter was first heard and when the San Andreas was included, should it have been included? That's, I think, the most focused point today. And I think the motions on scope, I'm hoping that, again, these may shake out if pending resolution of that fact issue. But again, all we have today is a motion to dismiss. So that's, as I see it, commissioners, the crux of the motion today. So before we hear oral argument from the council, I certainly would stand for any initial questions.
No questions here.
So I think as we turn things over, obviously, you've got voluminous pleadings here. I don't think we need counsel to, the commission needs counsel to walk through all of the details. You know, I recognize we have two motions to dismiss, different parts of the cases. We have motions about the scope of the hearing, which present overlapping arguments and issues related to it, but I think consistent with Council Rubin's suggestions, it would be helpful for the commission to hear from the parties on the core issues of the case, you know, which at the end of the day, are there recoverable reserves in the San Andreas? Clearly one's in dispute. Is Goodnight's injection into that formation impairing those correlative rights if they occur, and you know those correlative rights would attach to the party with a legal interest in the extraction of those rights, and then how do we narrow this case to a manageable set of parties and matters for resolution at the currently scheduled hearing in September. And so with that, I do want to go down the council table. I'm obviously familiar with the various parties here, but we do have at least one new attorney present. So would just like parties to just, I know everyone's entered an appearance, but just flag who they're here representing so that we can know as we move it forward. And we'll start with Mr. Rankin.
Good morning, Chair Hughes, commissioners. May it please the commission. Adam Rankin with the Santa Fe office of Holland and Hart, appearing on behalf of Goodnight Midstream Permian LLC in these cases. With me today, who will be also entering a formal appearance the next 3 weeks, is my colleague Nathan Jurgensen, who is over here to my right. He'll be actively participating in my absence over the next 3 weeks.
Okay. Mr. Tremaine.
Mr. Chair, commissioners, thank you. Jesse Train for the Oil Conservation Division. I'm standing in today for Mr. Moander, who I expect to return to this case at the next meeting.
Mr. Suazo?
Good morning, Commissioners and Mr. Chair. Miguel Suazo with the Santa Fe Office of Beatty and Wozniak, appearing today on behalf of Pilot Water.
Myrna Padilla, appearing for Empire in New Mexico.
Good morning, Mr. Chair, Commissioners. Dana Hardy with the Santa Fe Office of Hinkle Shaner on behalf of Empire.
Machine?
Sharon Shaheen, Montgomery and Andrews on behalf of Empire, New Mexico.
Is there anyone participating virtually for any of the parties in this matter? Hearing none. I think we'd like to entertain, I think for kind of expediency as we sort of pack through it, 10 minutes from the parties to kind of sort of frame the issues we're thinking about today and sort of the stack of motions. There's arguments to say, hey, we could just go through them one at a time, but they really do raise overlapping issues. So I think it would be helpful to have some framing remarks from parties in 10 or 15 minutes so that we can begin unpacking in particular the motions to dismiss.
Mr. Chairman, Rip Harwood here. Can you all hear me?
Loud and clear.
Okay, thank you. I don't mean to slow anything down, that's for sure. But I'm not clear what my role is here. In discussions yesterday with Mr. Fuge, it was my understanding that I was the hearing officer for this proceeding, but maybe I'm just an observer. So, and good morning to everyone, by the way. I haven't seen you all in a while, but I'll be the hearing officer for the hearing in September. And I'm just wondering, this is my first OCC meeting, so maybe you could clue me in a little bit about what I'm taking good notes, among other things, but I need to know what my role is so that I don't miss it.
So Mr. Harwood, I think as everyone knows from the last meeting, when we set the scheduling order, given the size of the case, the matters, the commission also opted to assign a hearing examiner this for administration of the hearing, working through procedural matters, discovery, disputes, discussions that may arise as this case moves forward. I think for today, and I'll look to Commission Counsel to see if he disagrees. Mr. Harwood, I think it is mostly a listening posture as the commission works through motions to dismiss and other questions, as I think that will inform ultimately as we hand the case over today. This is your first hearing in the role as hearing examiner, because we will have the case in a little bit better shape as we move it forward in terms of scope and content, but also as the hearing examiner, if you have questions, again, please feel free to raise them. But I think right now it's the commission's going to be acting on the various motions to sort of set the scope of the hearing that will occur, and then subsequent meetings about discovery and other matters that would be within the purview of the hearing examiner.
Yes, Mr. Chair, members of the commission, Mr. Harwood, it's always a cardinal rule that hearing officers only would make recommendations at most on dispositive issues. What we have on a motion to dismiss is certainly a dispositive motion. And as long as we're here, we are going to provide guidance on the procedural discovery issues before us to make your job a little easier. We didn't necessarily have to do those, but we are, just because we had them before us before you were appointed. So today you're here to take good notes, as you say, sir. Listen in, and this will hopefully help you as hearing officer at the hearing.
Okay, thank you very much, Mr. Rubin. It's been a long time since our paths crossed, back, I think, when I worked for the Environment Department in the 1990s. But at any rate, I will take good notes. And I have to say that so far, if I were in your shoes, I've read the pleadings, I've analyzed the standing issue basically the same way that you have. With all of that said, I will turn off my mic and camera and pay attention. Thank you all.
All right, with that, and I appreciate that we have various motions initiated by various parties. I'm going to go ahead and have us hear from Empire Council first on these issues, then we'll go to Goodnight, the OCD, and finally Pilot.
Thank you, Mr. Chair. And you'd like to hear from us regarding sort of the format and the layout of where we are, right? That's the first thing. Okay.
Yes.
So, in these cases, we have competing applications by Goodnight and Empire. Empire, of course, operates the Eunice Monument South Unit and has done so for several years. The unit was approved in the 1980s. It was approved by the division, the state land office, and the BLM. So there are, of course, numerous parties involved and who have interests in the unit. It's not just Empire. And here, Goodnight's injection, of course, and it's our position into the wells within the unit, as well as the wells outside of the unit that are in proximity to it, are impacting the unit by reaching it or increasing pressure or other mechanisms that are impairing the production of hydrocarbons within the unit, and will continue to impair that and will limit tertiary recovery possibilities, which of course raises issues for the interest owners as well as the state of New Mexico, because of course there are substantial revenues resulting from the production of hydrocarbons within the unit. So it's an important issue for the commission to consider. The pending motions, the competing motions to dismiss, although they are different, and Mr. Padilla will address Empire's motion to dismiss Goodnight's applications to amend the unit. Those motions deal substantively with Goodnight's standing and lack of standing because it is not an interest owner in the hydrocarbons in the unit. With respect to Goodnight's motion to dismiss, that's a different type of motion because it's really based on pleading. The claim is that Empire did not plead sufficient standing. It's not that we don't have standing. So those are two separate issues. And so I will address that motion. And then with respect to the scope motions, which are impacted by the rulings on those motions to dismiss to some degree, Ms. Shaheen will address those. But I will say that I think the crux of the dispute on the scope is whether wells outside the unit are included, as well as whether other parties are included in those cases. So I think those are the main issues. So that's where we are on these things today.
Mr. Padilla?
I don't have anything to add. I don't have anything to add with regard to the procedural, what goes first and what's next. I will address the motion to dismiss whenever it's appropriate.
Mr. Rankin?
Good morning, Mr. Examiner. I think Ms. Hardy has, fairly summed up the issues. And I think that, what the commission needs to deal with here today and going forward in these cases are these competing claims and allegations about whether or not the San Andres is a economic hydrocarbon zone, more generally, and more specifically, whether within the EMSU, even if within the EMSU, whether it's appropriate to inject produced water for disposal purposes. The framing around these issues, I think, is fairly well laid out in the scope motion and in the motions to dismiss. In particular, the motions to dismiss Empire's applications to revoke injection outside the EMSU, and the scope of the hearing motion that we have filed and the division has filed. I think, without getting into merits, I think there's some significant questions Mr. Rubin has identified with the scope of the Statutory Unitization Act. And I think I've started to hint at some of those in the applications. While I didn't cite to the record or attach exhibits from the unit hearing record back in 1984, it's essentially a map, a trail map I laid out in the application. If you go through the hearing exhibits and the transcripts, I think you'll see that at the time the unit was created, very clearly, the oil column is limited to the Grayburg top. There's an effective seal or barrier between the Grayburg and Sandres. Otherwise, the water flood wouldn't work. They wouldn't be able to take water out of the Sandres immediately below and put it into the Grayburg. So I think, there's a lot of facts to wade through there, and legal issues. Also implicated is whether or not, when there's been no primary production in the San Andres within the unit, whether it's been reasonably defined by production. And because it hasn't been, and there's been no primary production within that portion of the pool, our view is that it's not susceptible to tertiary recovery under the Statutory Unitization Act. The Unitization Act expressly limits its authority to development subsequent to primary production. And there's a reason for it. And the reason is that the Statutory Unitization Act authorizes the commission to force interests into the unit who otherwise are unwilling to do so, and to force them to pay costs through production for their share of the costs of operating the unit. Where production is otherwise exploratory or uncertain, the Statutory Unitization Act is not intended to force people to pay for those costs. And that's why the Unitization Act is set up the way it is. So all that I think is important. I want to just raise that with you because I think down the road, it's going to be very important to understand. So other than that, and I got a little bit off track there, but I think, I think it's important to understand the scope, and for all these reasons around the Statutory Unitization Act, we think that the commission should focus its interests and its decision-making on these contested issues solely within the unit initially.
Mr. Tremaine?
Mr. Chair, I understand the immediate question to be about the posture and procedure of the case. And so I don't have any further comment on other than what's been stated about the procedure. We can provide our response to the various motions at any point the commission desires.
Suazo?
Thank you, Mr. Chair. Just to clarify, Pilot has entered into these proceedings with regard to the scope matters that are before the commission. That being said, Pilot's here a bit reluctantly given the nature and the extent of its interests in the EMSU. And so depending on what the commission decides today with respect to the motions to dismiss, that could impact the extent to which Pilot involves itself in future proceedings. But our primary position is to address the scope, given that Pilot has one well within the EMSU, the P15. It's a marginal injection well, but is nevertheless potentially impacted by what the commission decides in this proceeding.
I suppose maybe to kick it off with some questions, again, because there were comprehensive briefings here and sort of thinking through the two motions to dismiss that are pending. One relates to Goodnight's actions to amend orders R 7765 and 7767. And the other relates to case numbers that I'm not going to bore the record with reading, but all of the Empire cases to revoke injection authority for wells outside the EMSU. I don't know why I was adding an N. EMSU. Couple of questions at the outset that I had just sort of factually and would welcome the parties' input on it as it relates to the orders establishing the EMSU. And the questions I would welcome in sort of the motion to dismiss context. I had a question about how critical making that amendment is. And if you'll indulge me in a hypothetical, if the hearing shows that there are no recoverable reserves in the San Andreas formation, which is part of the unit, and injection is otherwise properly authorized, does it matter that it's within a unitized level? Because if there are no recoverable reserve, there's no impairment of correlative rights. So does the commission need to change those orders to get at that question? Or if there are no recoverable reserves and there's no impairment of correlative rights and it was properly permitted under the division's authority under the Safe Drinking Water Act, is it even an issue we need to get into? And if so, why? And I guess I'd welcome to hear from Empire first, since you're moving to dismiss those cases. And understand you may also touch on standing questions and there are other components in your motion that sort of pushing it, but would welcome your perspective on that sort of factual hypothetical.
Mr. Chairman, members of the commission, let me speak for Empire here. In answering your question about the San Andreas, it's not producing any oil at this time. At the time of the hearing in 1984, however, there was considerable discussion about inclusion of the San Andreas formation because there was a potential for tertiary recovery. Our main case presently is going to be that there are residual oil zones in the San Andreas formation, and therefore injection of very dirty water in that formation is going to destroy residual oil zones. That has still to be developed. So I don't, it's not a question right now whether or not there has been past production in the San Andreas formation. The potential for production in the San Andreas from residual oil zones is clear. Residual oil zones are being developed throughout the Permian Basin in a number of instances, and our main case is going to focus on residual oil zones. To say that the commission was wrong or that it made a mistake in 1984 is inappropriate. In 1984, Exxon and Mobil went at it in a contested proceeding, and Gulf prevailed on the statutory unitization. The Commissioner of Public Lands and the Bureau of Land Management approved that unit. What we don't see here today is that relating to standing is that we don't have Goodnight as a working interest owner or having any mineral interest or water right that it's asserting. The sole basis for their entry here is their profit motive. Profit motive that they are asking to eliminate the San Andreas from the unitized interval. There's really no basis other than the fact that they want to dispose of water in the San Andreas formation. Their primary focus, and as I read the response to the motion to dismiss, is they're saying that Goodnight has made a huge investment in its pipeline and disposal facilities. But that doesn't mean that you go and pick a dump site because it's convenient. So going to the standing issue, there's no injury. There's no injury. I disagree with counsel for the commission on whether there's a valuable property right. There may be that, but Goodnight certainly knew that that unit existed, and they knew what the vertical limits of that unit were. And they picked that simply from a profit motive. to the detriment of the owners of the working, of the unit. There is no, the BLM, the Commissioner of Public Lands are not involved in this case at all. From an affirmative standpoint, I've been involved in a number of units for contraction and expansion of units, but those cases are brought by working interest owners for further development of the unit or contraction where production has already declined. And it's unfair from a correlative standpoint for non-producing properties to be participating in unit operations or revenue. So
is your contention, Mr. Padilla, just to clarify, and I will give other counsel opportunity to argue, that the mere creation of a unit in 1984, which I think everyone will agree occurred at a time when seismic data wasn't as good, modeling wasn't as good, created effectively, it sounds like the argument, a rebuttable presumption that there is a residual oil zone in it, notwithstanding the fact that the San Andreas Formation writ large is used for disposal across the basin. I guess I'd like to understand, is the argument here that just creates a presumption that there are correlative rights in the unit just because it was pooled at some point in time and forevermore we're stuck with geotechnical engineering from 1984?
I think
Or reservoir engineering from 1984?
Well, essentially, what we're having is the applications to delete the San Andreas as a reformation of those agreements. The commission doesn't have that authority. We've cited a number of cases where the commission has ruled on pore space or property rights, saying we don't have jurisdiction to do any of this thing. These applications by themselves would delete the San Andreas Formation. And I don't think the commission can go that far. I mean, we've cited the unit agreement, the operating agreement, where working interest owners can amend the unit, but the commission shouldn't be changing those agreements. And I agree, you can have a corollary in terms of residual oil zones with better information today, where you have residual oil zones in the San Andreas throughout the Permian Basin. We're contending that residual oil zones exist in the San Andreas underlying the unit.
Mr. Rankin? Thank you, Mr. Padilla.
Thank you, Mr. Chair, commissioners. You know, Goodnight went into its disposal operations in this area with the understanding, and I think that to assist my discussion, I am going to share my screen because I do think it's just helpful to keep in mind what we're talking about, if that's okay.
Yep.
So what we're talking about here is on the screen that you can see in the red outline is the unit boundary for the EMSU unit. This is the unit boundary that's been in place essentially since its creation back in 1984. The wells that are highlighted yellow are all the wells that are within the unit boundary. The wells that are not highlighted are those that are outside the unit boundary that Empire is seeking to revoke the injection authority for. With the exception of this Parker Energy well, this has not been the target of an application to revoke. Okay. Otherwise, every other well, including some that haven't been drilled, are subject to the applications to revoke. Included with the information on each well is the first date of injection. So you'll see that there are two wells in particular that have commenced injection decades before the unit was created. The first one up here, just outside the unit boundary, is the EME SWD 33M well. That well has been injecting since 1960 and now is above 60 million barrels injected. The other well that is in the unit boundary is this EME SWD number 21 well. That well has been injecting since 1966 and is upwards of 40 million barrels. So at the time the EMSU was created, it came to disposal within the San Andres zone. There was active disposal occurring at that time for decades. When we came to, when Goodnight, first came to this issue and was looking at disposing, it identified the EMSU as a prime location for one reason. It had been the source of a water flood. So for decades, the operators of that unit have withdrawn millions of barrels from the San Andres zone. Upwards of 350 million barrels have been withdrawn over 3 decades, creating a massively depleted zone that was ideal for disposal. So Goodnight initially came up to the boundaries of the unit within a mile or so and initiated its injection disposal activities there. It had approached XTO to inquire about, disposing within the unit, and those discussions were ongoing when this well, the N11, the P15, were approved by the Division for Injection Disposal in the unit boundaries. Having seen those wells be approved for disposal, Goodnight then applied itself for wells to dispose within the unit boundaries. 4 of them. They were approved. XTO never objected. So those wells would then commenced injection operations and were going along just well. In the interim,
Mr. Rankin, I'm sorry, who was the operator of the P15 well?
the P15, at the time, Rice drilled the well. Rice was the one that drilled it, but I believe it's in 22, they transferred the rights to Al, and Al's currently the operator still.
Okay.
Okay. The other wells, the N11 and the EME 21, are Rice wells. Now they have recently been transferred. The operatorship has recently been transferred to Permian Line Service. So they're currently operated by Permian Line Service. So we came.
And Mr. Rankin,
Yeah.
sorry, when you made the remark that when Goodnight developed it wells and there were not an objection from XTO, is that because XTO or an XTO entity was the operator of the unit at the time?
Right. XTO is the operator of the unit. They got notice, of course, that Goodnight was proposing to drill these wells and commence injection operations. And there was no objection. They were approved. It went forward. So at the time, based on the history, based on the fact that there was existing disposal long before the unit was created, not only in the unit, but offsetting within the San Andres itself, and based on the fact that the division had approved 2 recent disposal wells within the unit boundaries, Goodnight understood that it was not necessary to amend the unit interval to address the fact that the San Andres was included in the unitized interval. Now, that position was maintained up through the time that we filed our application for the Piazza well, which is this one here in the middle of the unit area, the Piazza SWD. By the time that application was filed, Empire was the operator of the unit. They objected to the injection. It went to hearing, and they took the position that there should be no third-party operators disposing of produced water within the unit boundaries. We made an argument to the division, and it's part of the case record, that it's not necessary to amend the unit interval because as long as we're not interfering with correlative rights resulting in waste, otherwise impairing unit operations, and otherwise meet the requirements of disposal approval, that we can get approval from the division and proceed without having to deal with the legal issues around the Statutory Unitization Act or the unit order authorizing the unit. Now, Empire, took the position at the time that no, you need to go amend the unit. That's what they should do. You need to go amend the unit. We disagreed. We went through the hearing, and we ultimately were denied our application, partially on the basis that the San Andres was included within the unit, It was included for purposes of providing a water source. When you read through and review the testimony at the hearing, you'll see that they expressly identify that the San Andres is going to be the source of water. They're not going to conduct water flood operations within the San Andres. The oil column extends from the base of the Grayburg up into the Penrose, but it does not go down into the San Andres. Mr. Padilla made the statement that actually at the time of the hearing, there was a lot of discussion about the potential for tertiary recovery in the San Andres. I'm going to tell you that I spent a lot of time on that transcript and on the materials, and it was never discussed. Okay, it was discussed for the AGU to the southeast briefly, and you'll see in the Piazza order that there's a reference to the potential for tertiary recovery, but it cites to a different unit. There was no discussion at the time of the EMSU that there was any possibility of tertiary recovery CO2 flooding in the San Andres. That discussion was related to the AGU. Okay, so there was no prior discussion about the San Andres as a hydrocarbon bearing zone. So based on the order that the division issued denying our authority to inject in the Piazza, with the taking the position that the San Andres was necessary and important for the unit operations as a water zone, and that Empire at the time had put forth enough evidence to suggest that there might be concerns about waste and flooding out a potential hydrocarbon zone, and that they deserve more time to continue to assess the San Andres for hydrocarbon potential, they denied our application. Based on that ruling and Empire's continued firm position, we felt we had no choice but to apply to amend the unit interval. That injury to us, to Goodnight, and to their ability to continue to operate not only their proposed 5 wells that are subject to commission's review and approval, but the 4 existing injectors essentially put us into a corner where we had no choice but to amend the unit interval to remove the San Andres, because at the time the order was issued, at the time the case was presented, there is no question that there was no thought, but that the San Andres was solely going to serve as a water management zone, both for disposal and for water supply in order to repressurize the Grayburg. And so our view is that based on the facts and evidence presented at hearing at the time the MSU was created, it does not meet the requirements of the Statutory Unitization Act. It should never have been included, and that those orders as to the San Andres are void ab initio. So we think it's imperative for the division commission to revisit those orders and do what it should have done initially, which is to recognize that, underground sources of water are subject to the New Mexico Constitution. They're not to be included in a unit because there's no hydrocarbons. Number one, and number two, the San Andres is not part of a pool. There was testimony at the time of the hearing that their hydrocarbon, the oil column, is limited to the Grayburg, which is why they are sweeping only the Grayburg with their water flood. I think the necessity here for addressing this issue is now kind of plain, because I don't think this dispute will go away unless it's addressed by the commission. Empire is raising the claim that they want to be able to come in and do a tertiary recovery under their order, under the Statutory Unitization Act order. The EMSU, contrary to Mr. Padilla's argument, is a creature of New Mexico statute. It is a creature of New Mexico statute. And it's limited and defined by the conditions and requirements of the Statutory Unitization Act. It requires any pool that's going to be unitized to be demonstrated that it's defined by primary production. Any pool or portion of a pool has to be defined by primary production. The San Andres, as we just heard today, has not been. There is no primary production. Every time an operator penetrated or perfed the San Andres, all they got was water. They came back up full, they plugged it off, and they produced from the Grayburg. There is no primary production in the San Andres. It is not subject to the Statutory Unitization Act. There's no way that Empire should be allowed to go forward with the tertiary recovery plan in a zone that has not been defined by primary production. So to the extent that they want to do that, if they think they've got evidence to demonstrate that there is now potentially economic recoverable hydrocarbons in the San Andres, I think they have to come back and do so through an exploratory unitization, exploratory unit. It's not susceptible to statutory unitization. So that's for them to figure out. But for the commission, I think the issue is plain, that they should rectify what was done incorrectly in the past, amend the issue so that we don't have this dispute going forward, and we can go about our business and dispose of produced water in the San Andres.
I did have one question, because you brought up the sort of necessity to amend these orders based on the OCD's decision in case number 22626, order number 22869, which was concerning Goodnight's Piazza well. And, you know, at least if I'm understanding your argument, there was some contention that there was a finding that the commission found some preclusive effect of the unit, when instead, at least as I'm reading that order that I pulled up, you know, essentially it was a finding that in that proceeding, it wasn't necessarily that the scope of the EMSU was the problem. It was that Empire had provided sufficient assessment for the continued assessment of the unitized interval for potential recovery of hydrocarbon resources, which ran into our statutory charge, or the OCD statutory charge, to prevent the drowning out of water or stratum or part thereof capable of producing oil and gas. And that we did not necessarily, the division did not necessarily hang its hat on the existence of the EMSU and the strata within it as preclusive of disposal there, assuming you could show that such disposal wasn't going to prevent the drowning out of any stratum capable of producing oil and gas, which again gets to my central question of, do we need to touch the orders at all, or can the commission find that either find that Goodnight's disposal does or would not? Yeah.
Thank you. I'd like to just comment on that and remind commission that there's a basic judicial principle that I think applies here. You only decide what you need to decide, and your order should only cover what you need to cover, which is why it's a very important question. Do we need to revisit the order defining the unit? Mr. Purdie, I didn't hear, and I'm not, you know, obviously we're phrasing it as a hypothetical, but if we did not, as a factual matter, find that there would be, for lack of a better word, impairment or production of hydrocarbons, or impairment of the production of hydrocarbons, I'm simplifying, would we still need to change the unit? And Mr. Rankin, I'm not sure if I thought your position was, if there is no impairment or production with the San Andreas, that we don't need to. I know you're hedging quite a bit, for lack of a better word, and I understand why you needed to file a motion to amend the unit as perhaps a hedge. But is it your position that, as Chairman has said, do we need to even go fix the unit if there's a factual inquiry that results in there's no production of hydrocarbons there, and it is no impairment of the other production in the EMSU? Mr. Padilla?
Well, I think that assessment is basically correct, is that you don't need to touch, as the chairman, you don't need to touch the orders. If you find that ultimately that dumping into the San Andres is appropriate.
Okay.
Mr. Rankin argued in his argument, he's saying that you don't need to touch the unit if there's no production there. There's no oil and gas production. We're contending that there is, and that there will be an impairment of the reservoir by introduction of very dirty water.
Yes, and I think that goes to the definition of what a pool is under the Unitation Act. It refers certainly to the production, but it also talks about each zone of general structure, which does imply, I'm relying more upon what I learned in the state engineer's office about hydrologic connectivity, but I think that does imply that if it impairs the production of those working interests, it's still a problem. But yes.
Mr. Rubin, you were correct. I mean, we initially believed that it wasn't necessary to address the Unitization Act or orders. I think as you've heard Mr. Padilla contend, that their view is that it's firmly within the unit and should be and remain in the unit. Our view has necessarily evolved and in closer scrutiny of the hearing testimony, exhibits, and evidence that was put forward to the commission at the time in 1984. I believe strongly that the commission's decision at the time was an error. It was a legal error, and has a consequence, rippling effects through time to this point. And I believe that it is necessary to correct at this point.
It is, okay.
I believe it is, and I understand. I'm unable to pull up the Piazza order, and so I don't have the language right in front of me. For some reason, my Adobe Acrobat's not allowing me to open this file, but I think it's a little vague, Mr. Chair, that there is some discussion about the use or necessity. There's some discussion in the order about the fact that part of the costs were, and the justification for the unit was the fact that there are going to be these water supply wells that are producing from the San Andres, and that was part of the justification for inclusion of the San Andres in the unitized interval. We read that broadly as in the sense that we thought Empire would, and so we don't, I'm not relying solely on the Piazza order for the basis that it must be addressed or resolved. I do believe, looking at the exhibits, testimony, and the facts put forth at the commission, that it was an error, and I believe it's contrary to the statute and it needs to be corrected.
I have some other questions my fellow commissioners may, but I did want to hear from Mr. Tremaine.
So, Mr. Chair, I'm going to give you the normal lawyer answer, which is it depends. So to directly answer your question, I think it's an apt question that I think really goes more to order of operations and structuring the hearing appropriately. I think there are two threshold questions here, boiling this down to a very simplistic two questions. And one is that, is there in fact an ROZ? And second, is the injection negatively impacting the ROZ? And I think depending on the answer to that first question in particular, then what to do with that previous order that's largely going to dictate what the commission should see as necessary with that previous order. And so I think that there are quite a few factual questions that cannot be resolved, like the discussion here today is absolutely necessary to appropriately set and schedule the scope of the hearing in September. However, I don't think we can actually answer that question until we get to the presentation of evidence and the factual determinations that the commission may or may not make at that time. At a higher level, the division ultimately sees both motions to dismiss as asking the commission to reject sets of applications that raise larger resource and pore space management questions presented to the commission, and the commission should reject both motions to dismiss those applications and then structure the hearing according to whatever it decides about related to the scope, the scope question. If the production is not possible from the San Andres, then I think that there is a colorable argument that inclusion of the San Andres was an error based on new information. But I'm not taking that position. OCD is not taking that position today. as I said, that needs to be answered after a full review of the facts. And I just want to highlight, when distinguishing between other agency permissions and the Statutory Unionization Act and the orders, this commission retains all necessary authority to review prior orders based on new and updated information. There's concurrent jurisdiction, and the question before the commission is only whether or not specific aspects of prior orders were in error. The implications for what that does, or if it creates conflict with other permissions or orders outside of the control of the commission. That question, that's a remedy question, and it's not actually, I think, before the commission. So to Mr. Rubin's point, answer the issues and questions that must be answered by the commission only.
Mr. Suazo, anything or?
Sure, just a few points of clarification. And let me preface this by saying that, Pilot has not had the benefit of being involved in these various proceedings for as long as the other parties. We've only been, kind of really brought into this in the last couple of months. So Pilot hasn't had the benefit of doing all the discovery and due diligence and consulting its technical people and so on and so forth. That being said, I did discuss with my client about what their take is on some of the claims that were being made, and it's Pilot's position, preliminarily, that they are not aware of any residual oil zones that exist within the San Andreas Formation. So there's not, to their knowledge, any oil bearing concerns. Now, they do want the opportunity to be able to investigate that further, but that is their preliminary position. And they believe that the San Andreas can be used and really is only used for, water disposal. And Commissioner Bloom, I know you had a question about OWL. Just for the record and for your own clarification, Pilot essentially merged or acquired OWL back in 2022.
Sorry.
Mr. Schwartz, that was in reference to P15 well?
The
That's what I
P15,
thought. Okay,
that's
thank
right.
you. Yeah.
Do you have some questions, Dr. Impoma? Yeah.
Questions. So, Mr. Rankin, you talked about how, let's say there has not been any primary recovery in the San Andreas. So even if there is a recent technology that shows that there is some kind of oil in there, we should still not permit that.
No, thank you, Dr. Ampoma. It's an important question and a distinction I want to make in partial response to Mr. Tremaine's discussion. What I'm saying is that under the Statutory Unionization Act, the MSU is a creature of statute. Okay, in other words, what Empire is authorized to do and how it's authorized to act and what operations it's authorized to conduct are limited and constrained under the terms and conditions of the act itself and the unit order that was issued by the commission, okay, in approving the unit operating agreement. When the unit was approved, it was limited to water flood operations, okay? And that's because for a number of reasons. Number one, that was what they asked for. And they asked for water flood operations for secondary recovery within the Grayburg zone. And they went into hearing and they said, we've got a oil column that is from the base of the Grayburg up into the Penrose. And we intend to take water from the San Andreas and flood and produce from the Grayburg. As a result of the demonstration that they made, the commission had concerns about recovery, about costs and recovery, and they limited the application of their allocation formula to a certain volume of oil, okay, under secondary recovery only. So under the terms of the order and the terms of the Statutory Unionization Act, Empire is limited currently to conducting only water flood operations and only allocating production in accordance with the order up to a certain amount of recovery. I don't think they've reached that yet. I'm not sure they ever will. Okay, but that's the limitation of the order, number one. Number two, under the terms of the Statutory Unionization Agreement, rather the Statutory Unionization Act, as a condition for authorizing the forced contribution or commitment of interest into the unit area, the legislature has determined that it's appropriate only to allow operators to do so where zones, a pool or portion of a pool has been defined initially by primary production. Okay. So under the Statutory Unionization Act, as part of a condition, a requirement to getting an order authorizing them to force the interests of other working interests into the unit, they must show that it's been reasonably defined by development. So they did that at the hearing, and they showed that the Grayburg, of course, which has been produced since the 30s, a lot of these wells are 80 years old, has been defined by development. And that's what they had a technical committee for. This technical committee met for 4, 5, 6 years in advance, trying to figure out how best to develop the Grayburg. What they haven't done is, under the Statutory Unionization Act, they haven't showed what they need to show, which is that the portion of the pool that they're now saying has hydrocarbons has been defined by development, primary development. I'm not saying they can't go in there and produce it. If they are, if they can get somebody to voluntarily pay for the money to deepen their wells, to bring in CO2 resources, to upgrade their 80-year-old wells and pay for all those capital costs. I'm not saying they don't have the ability to go do that if they want to go do that. But number one, I'm saying the commission made an error by including it as a pool because there's no hydrocarbons. So it should never been part of a pool. And number two, it shouldn't be included in the Unionization Act because it's not defined by production. And so if they want to go do that exploration, they can do it outside. They must do it outside the authority of the Unionization Act and their current order, because the order doesn't authorize it. Now, Mr. Tremaine raised the issue that, potentially, if after a full evidentiary hearing on the merits, we see that there's no ROZ in the San Andres, then maybe the commission has justification to exclude the San Andres from the unit. My point is, as an initial matter, as a threshold matter, the commission must first evaluate whether or not the San Andres was properly included because of the legal issues I just raised. It needs to be addressed in the first instance.
Can I
Ms. Hardy?
respond? Thank you. So I disagree with Mr. Rankin. I think that the commission's jurisdiction is not limited, of course, to the Statutory Unionization Act. The commission's mandate under the Oil and Gas Act is to prevent waste or protect correlative rights, and as set out in the Piazza order, to prevent the drowning by water of any stratum capable of producing oil and gas. So those are the commission's paramount obligations. It's not limited to the Statutory Unionization Act and whether a formation was correctly or incorrectly included. It's much broader than that. And here, Good Empire is alleging and will demonstrate at hearing that injection into the San Andres is impairing correlative rights in the unit. It's not just that there is a unit that exists so they can't inject. It's not that simple. There are correlative rights that are being impaired, and that's what we will show at hearing. So I think that's the crux of the issue that the commission and division need to decide. Even if there were no unit, those issues would still exist because there are correlative rights in the hydrocarbons. So I think that the commission does not need to address Goodnight's motions and applications to limit the unit. I think the crux of the issue is whether the injection is impairing correlative rights and resulting in waste. And I also don't think it's necessarily limited to whether there's a ROS, because if injection is impairing production from the Grayburg, which is in the unitized interval, that's also a problem. So the ROS is an important issue that would be addressed certainly at hearing, but that's not the only issue.
Dr. Impelman, did you have a follow-up?
Yeah, so I kind of tend to agree with OCD position because we need to address whether there is ROZ. If there is ROZ, then certainly the San Andres needs to still be part of the unit. So I believe I'm leaning in the direction that, like OCD is suggesting, for us to go to the bottom of it to know whether there is an ROZ existing, for us to more or less make a decision as to whether we have to exclude or not.
I don't mean to say that I don't think, I 100% agree that the commission must address the issue of whether there's going to be any waste or impact on correlative rights at all. I agree 100% with Ms. Hardy on that point. My only point is that I think there are some initial legal threshold issues that are inextricably tied to the question that must be addressed on the front end. Ultimately, of course, the issue is going to be whether or not is waste or impairment of prerogative rights. And we are 100% prepared to go to the heart of that issue with a demonstration on the claims about ROZ. Absolutely. My only point about this is just that I think it's necessary. I'm being a lawyer, no doubt about it, but there are initial legal issues that implicate the question, because if it can't be part of the unit, okay, if the San Andreas can't be part of the unit and it can't be part of the unit for a number of reasons, then the question becomes, how are they going to develop the ROZ? What's their plan to do it? And that also does weigh into this analysis. So that I just want to raise these issues at the outset for the commission because they are going to come up during the course of these proceedings.
I guess I just have a broader universe of questions because I'll go back, I know Empire has characterized the unit agreement as purely private. My understanding is the unit includes federal minerals and state minerals, so it's not really a private agreement. I know the BLM doesn't develop it as a working interest owner, but the minerals don't belong to Empire, XTO, or anyone. They belong to the federal government. Has anyone taken action? Are there any actions pending against BLM or the state land office, who all approved this unit because there were federal and state minerals to get them to contract it or change it?
Mr. Examiner, we have not approached the state land office. The state land office was actively involved in our cases that were initially presented before the division. And I don't have the full layout here of the state's interest, but I know that where Goodnight's wells are located here on the map, and I believe it's, where's my cursor? I believe these two lower sections are sections 20 and 21. And then I can't recall what that, because I'm not a landman, I can't recall the sequencing up here, but I believe the state land office owns a substantially the middle interest down here in the southern part of the unit. So during the time when we filed these applications, in every instance, the state land office was a party. And in fact, and I can't recall off the top of my head which one it was, 3 of the cases they actually appealed. 1 or 2 of them were outside the unit and 1 was inside the unit. They appealed up to the commission. They sought discovery from Goodnight on information about the San Andreas zone, pressures, injection rates, and so forth. We provided that information to them, and they, upon reviewing all that information, they withdrew their appeals at the commission level and stated that they didn't have any concerns about impacts on the unit.
Mr. Rankin, if you could stop your screen sharing, we had a request to do that.
I think to maybe advance discussion a little bit on some of these, and I'd like to hear from my fellow commissioners who obviously, if they have other questions, we can also go back to just sort of questions on the pleadings, but it seems clear in terms of figuring out what's the bite-sized piece for this hearing, that one of the core questions, regardless of the order, is whether there's an ROZ in the San Andreas. Mm-hmm. That's going to be at issue however we slice it or move it forward. That's a core question, and other things flow, bad because it's a water case, flow from that finding. And that at least in a discrete universe, while we could sweep in all disposal in the EMSU in the San Andreas formation and questions about residual oil zones in the entire San Andreas formation, that would be a massive unwieldy case. And so it strikes to me, at least where I'm headed, and I'd welcome some discussion from the parties on it, on the various motions to dismiss, is really Goodnight's motion to amend orders R7765 and R7767 is really maybe reserved for a later time once we've gotten at the factual question of, is there an ROZ in the San Andreas zone? And then as to scope and sort of relevance between the parties, that there's also a strong case to focus this hearing in September on wells that are in the EMSU. And while I understand technically that the water may not recognize a boundary and injection in the San Andreas and sort of other questions, it is discrete. You know, we can chop it up as sort of looking at the questions and moving it, and that maybe it's not a motion, maybe it's not we dismiss the applications, but we certainly stay them until such time as we've resolved those core questions, which are injection wells operating within the EMSU, and questions of whether there's a residual oil zone and whether there are impairments of correlative rights. And then that findings there have, will inform possibly those other cases that have been stayed as to whether we need to deal them. And I guess that's sort of what I was thinking, kind of listening to the argument and having reviewed sort of the extensive briefing, both on the motions to dismiss and on the scope of the hearing, candidly. And I suppose the last issue, I know there are pending cases before the division to revoke injection authority in the EMSU. And there were contention made about those parties not singling an interest in participating. The OCD's procedural rules, they don't really have to express an interest. The commission can pull those cases up, or the director could kick them up, whether the parties want to participate or not, candidly. And that's not a discretionary decision where there are joinder questions or anything like that. It's just the decision-making authority of the director to decide where to refer cases and move them up. And so I suppose there's an open question about what to do with those handfuls within that procedural frame for the cases. That at least seems to me, looking at all of this, as a reasonable bite for the commission to deal with in September that gets at core issues in the proceeding here without overwhelming us with saying, hey, we're going to look at disposal in the San Andreas writ large.
Mr. Chairman, members of the commission, I would heartily agree, and I believe it's the position of the division that there are factual issues, as Dr. Mpoma has also pointed out, precluding granting any motion to dismiss. And a denial, but I think it would be proper at this point to deny the motion to dismiss, because it is only a preliminary motion.
Sure.
And so the party should have that closure on the motion. And of course, with all respect to Mr. Rankin's contention that the law comes first, I see the factual issues getting to the bottom of whether there's an ROZ. That needs to be resolved in September. As part of that hearing, the parties can amply brief whether the unit itself needs to be amended. That is certainly part of the scope of that hearing. Those are, of course, legal issues, but that is part of what we have a hearing officer for. So at this point, as our decision tree, I would recommend denying the motions to dismiss. As to the scope of the hearing, yes, you have a lot of latitude. Parties, the people who aren't here, of course, and it even goes to a pilot, they can intervene if they want. You can bring them in. Or they can all sit back and see what happens what the result is of the factual inquiry in September. It's hard to decide what is more efficient at this point. I do appreciate Ms. Hardy's outlining of what exactly is at stake in the motion for scope, and drawing the line that, let's say, the wells that are outside the MSU is as good as any. So I would hold it's a more difficult issue to decide what to do about the motion to limit the scope. But at least I would recommend a motion to deny the motion to dismiss based upon what we've heard. I have not even heard from Empire that there is no issue as to whether there's an ROZ.
I think I'd like to hear from the parties, if that's okay. Machine? Can you turn on your mic, Machine?
Thank you, Mr. Chair. When you started addressing the scope, that raises the arguments that I was prepared to make today. I think that the first point, I'd like to make 2 points. And one is, as you recognize, there's no artificial boundary around the MSU when it comes to the formation. I am not a geologist, but I'm assuming, and I believe this is true, that any analysis of whether there's a ROZ that exists in the San Andres is going to include that area outside of the MSU. So you're going to be hearing evidence relating to that area outside of the MSU, whether you like it or not. And I think as a result, you can easily consider the Empire applications, relating to Goodnight's wells that are only approximately 1 mile outside of the unit. So I would suggest that you not limit the scope to the wells within the MSU. As for Goodnight's suggestion that we should be expanding the hearing by including those applications that were filed with respect to the Rice wells, Permian Line, and Owl, I would note a few things. First, today we will be filing motions to dismiss those applications. I understand that Goodnight opposes those. We presume that the division opposes those in light of their motion on the scope of the hearing. But Rice, I understand that Owl or Pilot also opposes dismissal of its application. Rice, however, supports dismissal of the applications with respect to the Rice wells. So we will be filing those motions today. Second, consolidating any of the Rice applications at this hearing will result in a deprivation of Empire's right to choice of counsel because the Hinkle firm has a conflict with Rice. So I'm sure you're aware it's black letter law that we have Empire has a right to its choice of counsel, and that right arises under the 6th Amendment. Third, the scope of operations by these third parties is simply not comparable to Goodnight's high volume commercial operations in recent years, disposing of highly saline and incompatible water from outside the area. Goodnight's operations far exceeds the operations of these other third parties. Now, I spent a lot of time yesterday looking at Mr. Rankin's Exhibit C, which was very helpful, and comparing it to OCD data that's readily available on the website. And I can provide you with the numbers comparing the volumes that Goodnight is injecting with the volumes that these other parties or these other operators are injecting. You may not want to hear that today, but I am prepared to provide that information for you. And I'll just provide you with one example, and that relates to the Owl well or the Pilot well. That's the P15 number 1, and it's Exhibit C. Goodnight represents that Owl injected 2,160 barrels since November of 2020. The Nolan Ryan well, which is the nearest Goodnight well, injected approximately 13.35 million barrels into the Nolan Ryan during the same time period. That's the most extreme example of the difference between the operators that are at issue. So for that reason, and again, if you would like for me to go through the numbers with respect to the Rice well and the Permian Line well that Goodnight has raised, as well as the Parker well and the MSU well that Empire has, I can go through the numbers on those, but I won't bore you with that if it doesn't matter. My point is simply that to include these third-party operators would simply make the hearing that much more difficult. That is what will make the proceeding unwieldy.
Is it your contention that those operators' rights won't be impaired by a hearing here? I mean, if we find, and if the commission were to find that there's a recoverable oil zone, that Goodnight's wells are flooding out, we would almost statutorily, wouldn't the division statutorily have to act against those other non-operators for their injection for doing it? And I think the presumption, yes, I understand Goodnight's scale is larger at the moment, but the OCD is effectively in part a produced water management agency at 5 million barrels a day of produced water generated in the Permian. If you shut off wells, the water will go to other wells. So is it your contention that volumes at Rice and others will remain low if suddenly Goodnight's wells were to go offline? I find that a little bit of a stretch, just given the broad need to dispose of produced water generally, and the volumes are not decreasing.
Well, first, those parties will not be collaterally estopped by anything that happens in these hearings.
I don't see how that's possible. If we were to find in a hearing that there's an ROZ in the EMSU, I don't know how in a subsequent hearing we could suddenly decide, oh, there's not.
Well, the Rice or Owl or Pilot or Permian Lion, if they want to intervene in these cases because they are concerned and want to have a say, then they have every right to do that, and the commission can allow that intervention. My point is we do not need to bring the applications that Empire filed, in which we are now dismissing, to be a part of the hearing.
And I guess I just have a follow-up question on the Sixth Amendment argument, which not completely would welcome in a discussion about how that might apply in the administrative context. But Empire's represented by 3 firms or 3 lawyers, maybe 2 firms. And the issue is an existing conflict created by the firm, which are waivable. There are ways to manage those conflicts if parties so choose, walling off and other components. It's unclear to me about how the OCD exercising its authority to consolidate cases that raise relevant issues. The fact that it may raise a conflict that counsel has to resolve in part by counsel's own business decision necessarily implicates the Sixth Amendment in its purest form, that we would be barred from pulling them up. I guess I'd like to understand that.
There is a Supreme Court case that recognizes that, and I think it would apply to the agency. And let me see if I could find it in my notes here. That's Sanders v. Rosenberg, 1997 NMSC-002. A party has a right to be represented by an attorney of her own choosing. And then the Chapel v. Cosgrove case, it's also a New Mexico Supreme Court case, 1996, NMSC-020. In that case, the court reversed a trial court's disqualification of an attorney from representation because the grounds for disqualification were insufficient to overcome the right to representation by an attorney of the client's own choosing, relying on American Cable Publications, a 10th Circuit case, which stated that a corollary to one's right to self-representation under the Sixth Amendment, quote, is the right of representation by counsel of his choosing. So those are the cases that I found that relate to this. I don't think counsel is required to seek consent of waivers. If there's an issue,
but we're not proposing to disqualify Hinkle Shaner. We're making no, in pulling them up, we're making no assumption about Hinkle Shaner's qualification, that you may have an ethical obligation with respect to representation that complicates it would seem to basically say that a large firm's decisions about who they represent forces hands in terms of how we scope cases, which I think goes beyond what either of those rulings require. I'm looking to commission counsel, but.
Thank you, Mr. Chair. Yeah, I'm a bit at a loss. I don't believe this was in the briefing, your Sixth Amendment issue. Did I miss something there?
There is a paragraph in the response to the motion on scope, I believe, that raises this issue. I
Mhm.
don't recall whether we cited the cases in that response, but I think I'm providing you with the case law now. I realize that this is not a disqualification case per se, but by consolidating these cases, you are effectively disqualifying Hinkle from participating because it has a conflict. And as we all know, Ms. Hardy has provided a tremendous amount of work on behalf of Empire to date on these cases. So by consolidating the Rice and the Permian line case, we would be effectively without Ms. Hardy's assistance.
And is it your testimony on the record that it would be impossible for Hinker Shaner through commonly accepted means, ethical screens, and other things like that to manage the cases? And I will say, having worked at a very large law firm, I'm aware of these tools to do complex cases. Are you saying it is impossible for Hinkle Shaner to do that? Or are you simply stating that Hinkle Shaner is unwilling because it's not required to?
Well, first of all, I would defer to Ms. Hardy as to what Hinkle can do. But in my mind, Ms. Hardy cannot, in her mind, represent two clients who are adverse or would be adverse. I mean, she'd have to like have a division in her head. I mean, that's impossible for Ms. Hardy to be able to do that. And Hinkle firm is not a huge firm. I mean, it does have 2 offices. But I don't believe Ms. Hardy would be able to do that. And I can't speak to whether waivers would be possible. My only point is we have Empire has a constitutional right to its choice of counsel, and to consolidate those cases would result in deprivation of our constitutional right to counsel. There are other reasons that the Rice application and the Permian line application should not be included, and I'm happy to go over those if that would be helpful for you in making that decision.
Mr. Chair, there's certainly a difference, and I want to make sure the commissioners are clear as to the scope of the hearing, as to where the evidence may lead in the case. We're just deciding whether to include other parties and other applications. None of this will limit in any way the evidence that the parties see fit to submit in September on these issues. And I think her point, we could avoid the Sixth Amendment issue. I'm not saying there's any merit to it, but certainly if whatever other potential parties wish to intervene do, that's fine. But if they don't, we're not trying to do we don't need to do a full scale adjudication. If this commission decides after a September hearing that there is an ROZ, that there are these factual issues, we can then further make sure that nothing happens on the ground until we deal with the rights or potential impairment of these other parties. If we get there. I mean, again, this reminds me of the difficulties of adjudicating a whole stream system. Do we try to do a full-scale adjudication, or do we just adjudicate these parties' issues vis-a-vis each other? And again, because we're not limiting the evidence that these parties may bring, it may include what happens to wells outside the EMSU. I mean, I suspect as you are, Chair, about the relevance of the Sixth Amendment here. But it would probably be simpler to simply let this hearing proceed. And it is your discretion, Chair, of course, to bring into this as the division director, whatever other, but we do have a hearing in September.
Yeah.
And there's a lot, as an attorney, boy, that's not a lot of time to prepare. And for a case of this magnitude. So we could protect, you would not be remiss in your statutory duties as commission by simply proceeding with the scope we currently have. And with the parties we currently have.
I'm going to give some of the other parties an opportunity, Ms. Shaheen, to comment on some of these issues, unless you had an immediate follow-up.
My only follow-up was, I believe that both Rice and Pilot have now moved to intervene in these cases. That's my only other addition.
Mr. Rankin?
Thank you, Mr. Examiner. I mean, a couple of things you raised at the outset before I get into the scope on the motion to dismiss, motions to dismiss. I understand the commission is contemplating denying those initially and allowing the parties to come back at a later time. I think that's fine. And I think partly those motions hopefully educated the commission. We do plan to file a summary judgment motion on the applications to amend the unit interval. I understand that the commission, my position on that is that it would not preclude in any way the commission from hearing the ultimate issues on the ROZ, whether there's ROZ recoverable or not. But I do want to make clear that we are going to be filing that motion for summary judgment in advance of the hearing. I think it will help direct the issues, legal issues for the commission going into that hearing. On the scoping issues, it's true. Yes, Pilot now have.
I'm sorry, Mr. Rankin, real quick, one more time, what would be the scope of the motion for summary judgment?
It will be addressing the applications we filed to amend the unit interval and the special pool. Okay, so the summary judgment that we're going to be filing will be addressing specifically tying the facts to the legal, to the law, demonstrating that the St. Andrews should be excluded from the unitized interval and from that special pool. Okay. Now on the scope, it's Pilot / OWL and Permian / Rice have both now intervened in the case, in the cases, but they haven't themselves requested that their pending applications from at the division level be referred to the commission. I understand why they would not want to do that. They want to dip their toes into this debate without actually putting any skin in the game. And I understand the reluctance to be dragged in. And intervening certainly is an opportunity for them to make their voices heard and to do so without actually having the risk potentially of an adverse decision. Now, to your point, Mr. Chair Hughes, I don't see how the commission can make a decision that's adverse, say, to these operators and have it not substantively affect their authority to inject in it. And you know, obviously they would come back and argue we have a right to have a separate hearing on this, and we want to present our own evidence and testimony, and that would be make no sense to require them to do that at a later time. It'd be it may result in conflicting decisions, and it'd be administrative burden on the commission to have to hear these cases subsequently from different points of view. So I think it's important to keep that in mind. If I may show my screen again, I want to make a point about something, and I think this is important to understand. Mr. Hughes, you raised this issue. The P15 here is a well that's isolated. It's not connected to a pipeline. Okay, that well is maintained. The authority to inject is maintained periodically by produced water being trucked to that well and being injected. The N11 up here is connected to a pipeline system. It's connected to the Three Bear Delic pipeline system recently. Goodnight has an arrangement with Rice / Permian to dispose of some of this water in this well. Okay. I don't see how, I mean, of course, if we lose our authority to inject, that well is going to get a lot of water, a lot more water than it's getting right now. I don't see why the commission would be reluctant to bring in these cases. There are currently cases pending. They involve the same exact issues. They're under the same exact legal framework under the Statutory Unitization Act. Any decision that the commission makes with respect to the San Andreas in this area is going to directly impact their rights and ability to continue injection. I think the issue about choice of attorney is the tail wagging the dog. They got 3 law firms. Montgomery and Andrews handles massive cases against, representing the state. They're more than adequate with Mr. Padilla's experience to address this case if, in fact, Hinkle is unable to resolve the conflicts. that issue is the tail wagging the dog. My understanding, now I haven't, because no cases were cited, no arguments were made about this in the briefing. We have been unable to review the Sixth Amendment arguments. I don't believe it has any merit. I'm not aware of any situation where, despite conflicts or any other reason, that a client is authorized to insist on having more than one attorney represent them at any kind of hearing. Number one. Number two, my understanding is that Sixth Amendment argument, it's not appropriate. It can't be used as a sword to preclude a substantive argument or substantive issues from being heard. And here, the substantive issues is whether or not these other three wells are also impairing and impacting the correlative rights and affecting waste that Empire claims is occurring. Empire's testimony that they submitted to the division repeatedly says that no third-party injection should be authorized within the unit. None. All disposal wells within 2 miles of within the unit within 2 miles should be revoked and banned. And then any wells from 2 miles to 5 miles should get approval from the unit operators. That's their position and sworn testimony. So I don't see how really what they're trying to do is avoid a conflict. They just want to avoid a conflict. And I don't see how that justifies limiting in any way the substantive issues that need to be decided by the commission. Now, I understand, I've spoken with Mr. Suazo and I've spoken with Mr. Beck, who represents Rice and Permian. And I understand no client wants to be in a position where their valuable injection rights are at risk. I understand that. Goodnight doesn't want to be in this position at all. Nor do we think we should be. But unfortunately, that's where we are. And I think it'd be important for the commission to hear from these operators, not just on a basis of having intervened, but actually with skin in the game. So I think I would encourage the commissioner and the commission's commissioner to pull those cases up and have the full vetting of these issues before the commission. I think it can be, yes. I mean, I think Goodnight has done a lot of work on this already. We do not want to delay the hearing. We have no interest in delaying this hearing. And we're not encouraging the addition of these parties in order to cause delay or in order to force a conflict on any of the council. That is not our motivation. Our view is that that's something that it's Empire's issue. Empire as a client has created this issue. And it's not something that Hinkle or Miss Hardy has created. It's something that Empire itself has done. So I think, with that, I think on the scoping issue, the other thing I want to say on scope, Mr. Commissioners, and I know you may be aware, it's been referenced in some of the briefing, it's been referenced in the motions to intervene, but there are 2 pending district court cases. Okay. Empire has filed a lawsuit against Goodnight down in the 5th Judicial District Court, seeking making similar claims as they make here. We briefed a motion and argued that that case should be stayed and the proceedings should be stayed pending under primary jurisdiction, pending allowing the commission to first address these factual issues. The court in that case agreed and said, basically, I can't imagine a more apt situation for the commission to first address these issues. It's something for the commission to decide initially. While those arguments were being briefed, Empire, through only Montgomery and Andrews and Mr. Padilla, filed a parallel lawsuit against Rice Operating, Permian, and Owl and Pilot. So to say that somehow they are unable to proceed here administratively when they have filed a very complex lawsuit down in the 5th Judicial District without the aid of Miss Hardy is confusing to me. I don't understand the basis for that position. Okay, they chose to file a lawsuit with only 2 law firms. That was their choice. Okay, they're pursuing their claims in district court with only those 2 law firms. They have not dismissed those complaints, and as I understand, they do not intend to. Now, the fact that they do not intend to dismiss those lawsuits, that lawsuit or either of those lawsuits, indicates to me that It's even more important for the commission to hear in the first instance the claims as to all those parties. The court has ruled that it's imperative for the commission in the first instance to make a determination about these factual issues, about waste, about correlative rights, about the presence of hydrocarbons. So I don't see how Counsel for Empire can argue that they have a right, a constitutional right, to force the commission to separate these cases when Empire itself has decided already to pursue their claims in district court with only 2 law firms. That's a tail wagging the dog. And I think it's should be set aside. So Mr. Director Fuse, I encourage the commission to consolidate all these cases with the AMSU. The point that, by including these 2 additional parties and 3 wells is somehow more complicated than including 6 or 7 additional wells outside the unit, even if they're just Goodnight's wells that are going to each have to be evaluated on an individual basis based on the distances, locations, and geologic factors. I don't see how that makes any sense. I think it's far easier, more streamlined to address everything within the unit. There is not an arbitrary boundary. There's a legal boundary that distinguishes what's happening in the unit from outside. And that's the basis substantially for why these cases should be consolidated.
I'd like to give Ms. Shaheen an opportunity to respond on the litigation and other components because there were some issues that were outside the confines of the papers. So.
I believe this focus on the unit is somewhat of a red herring. And Ms. Hardy nailed it on the head. I think when she talked about what's really at issue here is protection of correlative rights and the prevention of waste. The unit boundaries and anything that all of those requirements in the order and the Statutory Unitization Act, that really, as I think Commission Counsel has recognized, that really has no bearing. And I think as the chair recognized, really has no bearing on whether correlative rights are being adversely impacted and whether there's waste that's occurring as a result of drowning a strata of a producing formation. So this whole focus on the unit and the statutory act, I think, is a little bit of a red herring. So I just wanted to say that. I disagree that somehow leaving Rice and Owl and Permian Lion out of this hearing as a party with the applications that we are dismissing today precludes consideration of any substantive issue. And I don't believe Mr. Rankin identified any substantive issue that would be precluded from the commission's consideration if Rice, Owl, and Permian Lion applications are not consolidated here. Goodnight can subpoena whatever information it believes it needs from third parties. It could even subpoena their witnesses to testify. So I don't believe that requires those applications to be consolidated. As for the litigation, I think, again, that's really of no import here. We have not yet served the complaint on Rice or Owl. And the magnitude of that complaint is far outweighed by the magnitude of the litigation against Goodnight and the magnitude of the applications that are at issue with respect to Goodnight's wells. I don't think that is of any import here with respect to the commission's decision on the scope of the hearing. With respect to conflicts, I will now defer to Ms. Hardy.
Thank you. Ms. Hardy.
I'll just be brief. I think we could certainly explore matters like waivers, but I think I'm not sure whether that's a possibility or not. So it's not that we're not willing to do that. It's that I'm not sure that would succeed. And I think Empire is entitled to have its counsel of choice involved in these matters. And given the scope of the matters, I know there's been a lot of discussion of 3 groups, 3 firms, or 3 different attorneys. And I think the scope of these matters certainly warrants that. And I also point out that, as Ms. Shaheen stated, we are planning to file to dismiss the Rice and Owl applications today.
I have one factual question. With respects to the Goodnight wells that are outside the EMSU, is Empire the mineral interest holder in the minerals adjacent to those wells, or is your mineral interest solely bound within the EMSU, at least as to those wells?
Empire does have mineral rights outside of the MC.
Proximate to Goodnight's existing disposal operations?
Yes. Within that township and range, and I believe within the AGU as well, and within that same township and range of the AGU, which I want to say is 21 South 36 East and 22 South 37 East, but I'm not exactly sure. It might be evident on Mr. Rankin's Exhibit C.
My other commission, I have a couple more, but looking at my other commissioners.
I'm out of advice at this point.
Yep. We've had a lot of argument here this morning. And if I think back to some of the basic standards about a motion to dismiss and some of the arguments made by the parties, I'm not sure there's clear enough facts on either side to that it would be appropriate for the commission to deny the motions, even facts candidly not addressed by the proceedings. And I'll just observe for the record, I'm surprised the party didn't address it. Questions of participation in administrative proceedings leading up to this. I mean, there was no discussion of, I had a question here and I don't think it's relevant to these motions, but, Empire is a successor in interest to prior companies that held it. Those prior companies opted not to participate in administrative proceedings related to objection wells. There are, I think, legitimate questions about how are you bound by, actions by, predecessors and interests. I think there are maybe some similar questions in Empire's posturing of the case. All of that's to say, at least where I am right now, is I think the commission should deny the motion to dismiss Goodnight's applications to amend orders R7765 and R7767 filed by Empire, that those applications should be stayed. I think that issue actually clouds a little bit the questions that Ms. Shaheen so eloquently put are most relevant to our hearing in September, which is there an ROZ in the San Andreas? Is injection into the San Andreas going to impair it? Right. That's the core factual nugget in my mind that carries through all of these cases. Arguments about amending an order establishing the unit. If there's no ROZ, whether the unit includes it or not, I don't think precludes the OCD authorization of injection into that formation. So it's unclear. I think in terms of management of scope, we should also deny the motions to dismiss filed by Goodnight related to cases number 24021, 240 through 24024, 24026, and 24027. But for similar reasons of focusing the hearings and focusing the issues to be resolved in September, I would recommend to my fellow commissioners that those cases also be stayed until following a hearing that is focused on the presence or not of hydrocarbons in the recoverable hydrocarbons in the San Andreas formation, and the disposal wells that are using that formation within the unit. I'll recognize for the group that may have knock-on issues for external cases. It's going to have knock-on issues for other disposal operations in there, and I think it's knock-on issues independent of what applications people file. I think there is a pathway here where if there's recoverable oil in the San Andreas, the OCD independently with its own independent authority, will have to review injection authority within the ENMSU because we have potentially authorized injection that is flooding out a zone with recoverable oil, inconsistent with our obligations under its obligations under the Oil and Gas Act and its obligations to protect correlative rights. And that's an independent action OCD can initiate. And I don't know how we can do that and just pretend they're existing in little silos or rely on an assumption that injections are low. I am also sensitive to adding more parties at a late date and Council Rubin's suggestions to narrow what you have to put before you. But I also think there's a question of whether we, as the commission, should stay division cases 24432, 24434, and 24436 to let these issues, let the factual issues that will be developed here play out. They will have impact on those injection authorities that we can't say independently right now will be zero on the parties that are there, depending on the findings.
Mr. Chair, I'm sorry to interrupt. Of course, the Open Meetings Act always is the ultimate constraint. I am just looking through, there's a lot of numbers here. I'm looking through the agenda as to good night's motions to dismiss that you just started talking about.
Yep.
Are those on the agenda?
Yeah, they're on the
Where are we?
bottom of the agenda.
24.
Under the following consolidated meeting, motions regarding the scope of the hearing, motions to dismiss, all which were filed and logged.
Yeah.
And those cases are in the list of, if you look at the third bullet, right in the middle, case number, they're all in that run 24018 to 24027.
Okay.
The cases
Thank
are,
you.
the cases are there.
Okay. Thank you. Sorry.
So maybe I'm opening it up for some discussion on my fellow commissioners about that as a potential landing spot.
So the two issues, you're looking for comments on both of those, a recommendation regarding staying.
Well, denying both motions to dismiss.
Yeah.
Staying the cases by the motion to dismiss, and then basically moving forward with a hearing that is the EMSU injection cases in September as sort of that's the package, because if we resolve the motions to dismiss that way, the motions as to scope naturally, the natural consequences, that's where you'd end up is to scope. And then the sort of separate question is whether we want to consider staying 24432, 24434, or 24436, or whether we just want to leave those alone and let the parties take their own counsel on, potential impacts to their interests by participating or not in this matter.
I don't know. Sure, I don't know if we've heard from the OCD on this or if there's any thoughts there.
I'll try to be brief. Thank you, Commissioner Bloom and Mr. Chair. I think that the OCD supports, I think, much of the outline or recommendation that the chair just outlined. I think that the current cases before the commission related to the EMSU are the appropriate bite size for the hearing that's currently scheduled, and will allow all parties with interest in the area to participate. There's been a lot of talk and briefing about the issue of joinder and implication of due process concerns. I concur with the chair's statement that the chair and the director have the authority to elevate those cases. I'm dubious of the Sixth Amendment claims that were raised. So that's something that the commission or the director could do. But ultimately, I think that those concerns may largely be resolved by the entries of appearance this morning. And so while those other cases have not been elevated up My understanding is Rice and all of the other parties that we've been discussing have actually now entered appearance and notice of intervention. So unless any party is opposing those, I think that question's resolved and could be moot. And so you don't necessarily have to reach a determination on that. And all of the parties of interest will have an opportunity to take part in the hearing to address as we've discussed ad nauseum, the underlying ROZ question that's driving everything. In addition, OCD's technical team has looked at the information it currently has available. It's not a final determination, but it is OCD's position that the EMSU represents the most logical core set of facts raised by the legal questions in the various applications. And so I think that both in terms of the actual core of similar facts and circumstances, but also when you factor in and what we haven't really talked about is administrative efficiency. So I think the inclusion of all the parties who have now entered appearance will all interests will be appropriately raised at the hearing in September based on the scope discussed by the chair. But we're not going to have to get into the minutia of minor differences between particular wells. Is there going to be X amount of impact to this well versus that well? Because there will be, I anticipate factual distinctions between the wells, but not to the level of is there an ROZ and is the zone getting watered out? So I think that ultimately the questions that were raised put before the commission have been addressed. And if there is any ongoing concern related to the Sixth Amendment issue, that's something that OCD would ask time to address. I don't think it's an issue. I'm dubious. I also think that there is an issue with using it defensively rather than offensively. And I would just note as a practical matter, this is something that the commission and the division need to keep in mind because it's the common practice of operators before the division to cycle through using basically the entirety of the oil and gas bar in New Mexico. So when you look at the docket on any given day, the same operator will be represented by multiple different firms. So this is something that would come up potentially in the future. And lastly, regarding the motion for summary judgment raised by Mr. Rankin, I'm looking at the rules and I don't think that moves the needle on anything. I don't actually think that the commission is required to rule on that motion for summary judgment in advance of the hearing, so the parties can do what they want to do. And that could be essentially stayed until later. It's, in my opinion, 1915-416C gives the chair and the commission the discretion to rule on dispositive motions. So I think that's basically, I think everything is wrapped up by the entries of appearance, and that OCD's recommendation is that the commission move forward essentially along the lines that the chair laid out.
Mr. Suazo, as representative of a party that, if I'm characterizing this correctly, has one of those division cases we're talking about, but that's not currently at issue here, but has entered an appearance in this matter, would welcome your perspective on those questions.
Sure. Thank you, Mr. Chair. I guess let me address first the, wells within the EMSU and the wells outside of the EMSU. On behalf of Pilot, I think I can represent that they clearly prefer that the wells within the EMSU be dealt with on their own, and that the wells outside of the EMSU be left to, another proceeding if possible. With respect to the conflict, like yourself, worked at a 1,000+ person law firm, and conflicts like this are addressed relatively routinely, and I have every confidence that that can be done so here. That being said, it comes down to, and Michine said that she's going to dismiss the proceeding against Pilot and Owl. And that's a bit of a mixed bag from our perspective, because for starters, it's not being dismissed with prejudice. And that still leaves us with the potential implications of the district court case that Mr. Rankin referenced. And the district court case against Pilot is essentially identical to the one against Goodnight here. And the court in that case said at the hearing in late May that it would like OCD and the commission to weigh in on these various issues with primary authority. And so the concern from Pilot's perspective is what are the implications just because this OCD case goes away in the short term? What are the implications in the long term, especially because the commission needs to have the first insight that that will guide the court at a later date. So unless Machine is ready to represent that the case against Pilot will be dismissed with prejudice, I still think that at least for right now, Pilot's position is that they will oppose the dismissal because they want to reserve its rights to assert its rights over the formation in the EMSU going forward.
Mr. Chair, may we take a very, very brief break so I can talk to the chair offline for a few moments?
Yep.
Thank you.
Let's come back in 10 minutes, so 11:25.
Spells standard. Yeah. But different to the it's the fault.
It's the same name, but.
Oh, okay.
It's the same name. It's just that, the location is different.
Right. I think this one's spelled A-N-D-R-E-S.
Yes.
And then the fault is A-N-D-R-E-A-S.
Oh, then I'll.
That and Andreas.
Yeah, not even.
That's what I was wondering.
Okay.
In this instance, the same problem. Yeah, just referring to the. And the dress. Yes. Oh, yeah, okay. That's what he gets. Thank you.
Yeah, I think so. It's twisted. It's different.
So.
Oh, yeah, it's different. The spelling is different.
Yeah.
Yeah, the spelling is different. So there is no A here, but on the other one, there's.
All right, so I'll make it without the A.
Okay.
Just a bit. Thank you.
Okay, thank you. I don't think that would be. That's an issue. Yeah.
Yeah, so he understands that. But what he stated is division of appointments.
So, yeah.
We're good.
Oh.
There's one thing I didn't get wrong today, it's the Open Meetings Act. That's the one thing I'm an expert on here supposedly.
They're so good, yeah. What did you do?
Cherry Creek, sure it's.
That's what the reactions are for. That's right, yeah. Send them up there.
All right. We are back on. And I think we'd heard from all the parties on the proposal that I had put the sort of straw proposal that I had put out. Commission council correctly reminded me that any sort of commission action on cases 24432, 24434, or 24436 would be improper because while I know the parties to those cases were well aware of this hearing, it was not formally noticed on our agenda, those case numbers, that we might be taking any sort of action today, at least that the commission may be taking any sort of action on those. So therefore, I would like to make a motion that the commission deny the motion to dismiss, deny Goodnight's motion to dismiss. Sorry, let me start again. I'm going to make a motion denying Empire's motion to dismiss the applications to amend orders R7765 and R7767 that were filed by Goodnight. And those are in case number 24277 and 24278. And that motion be denied and that those applications be stayed pending the conclusion of the currently scheduled hearing for September.
Mr. Chairman, by stayed, you mean it'll proceed to hearing in September?
No, that they will be stayed and the OCC will revisit putting them back on the docket with the parties after the hearings in
Oh,
September.
yes, okay.
Mr. Reed, would we be okay to do both those? It sounds like we're doing two things on one motion. Is that okay?
Yeah.
Yeah, we're good. Okay. All right, then I so move.
I second.
Let the record reflect that motion was approved unanimously. The second motion I'm proposing to make is that we dismiss the motion to dismiss filed by Goodnight to dismiss cases 24021 through 24024 and 24026 and 24027. Those are division case numbers that are all part of Commission Case 24123. And much like the first, those cases be stayed until some future date following the hearing in September.
I so move.
I second.
Let the record reflect that motion was approved unanimously. And then the final motion I would make as to the scope of the hearing, and I think this flows from the actions that were just approved on the motions to dismiss, that the hearing in September has the following scope, that it is to address the potential for a recoverable residual oil zone in the San Andreas within the EMSU unit, and that it covers any applications to inject or applications to revoke the authority to inject for SWDs located within the EMSU boundary.
I so move.
I second.
Let the record reflect that. I should have clarified that it covers the Goodnight wells that are currently at issue before the commission.
I so move.
I second.
Let the record reflect that motion was approved unanimously. And I think that informs the scope of the hearing for September. And so the last item on the docket for today in this case is a request for reconsideration of the motion partially quashing Goodnight Midstream Permian subpoena, and specifically and I was authorized by the commission to act on the subpoena with advice from commission counsel. My decision to produce documents responsive to requests number 7 to 9, that was quashed in its entirety. And there is a request to restore that. I'd like to offer some brief arguments from the parties related to that motion, and we'll start with Mr. Rankin.
Thank you, Mr. Examiner. I'm going to go ahead and put these up on the screen. I'm not sure if everybody is familiar with these requests specifically, so I want to make sure that you all can see the language here, and I'll just quickly walk through what we're asking for. And I'm going to give a little bit of background because I want to explain how it came about that we were seeking this information. Okay, the first request here is a request for reserve reports for the EMSU, including related internal and external communications, emails, summaries, and so forth that reflect on or discuss or concern those reserve reports. So that's a kind of a general request that we're asking for. And the reason we're asking for not just the reserve reports, but we're asking for the communications and summaries because we want to understand what information or data was provided that relate to the preparation of those reserve reports. While we think that the reserve reports will identify the method, means, and the data that went into the calculation, we also want to understand what was provided to the parties that were doing the work. The second one, number 8, is similar, except it's a little bit broader. As Ms. Hardy pointed out, and she was speaking, just to be clear, in her response and Empire's response, they were taking the position that seems that we were only seeking SEC reserve reports. And that's not the case. We're asking for a broad range of potential reserves reports because we're trying to identify what Empire or its third-party engineering consultants have looked at and identified as potential for hydrocarbons in the San Andres and around the EMSU. So the second one, number 8, is asking for not just reserve reports, meaning proved reserves, okay, which is what the SEC requires, but we're looking for a broader range. We're looking for approved probable and possible reserves, which are defined terms under the Society of Professional Engineers guidance for determining reserves. So we're looking for a much broader range, anything that would qualify under those definitions for oil, gas, and hydrocarbons within the EMSU. And again, asking for reports that relate to those, including communications, because we're trying to figure out, and summaries, because we're trying to figure out what data went into the preparation of those reports. And the last one is all reserve reports or reserve estimates prepared to underwrite the acquisition of the EMSU. Again, and I'm going to explain why we asked for this in particular, but I'm going to do so by pointing to some testimony that Empire's Chief Operating Officer gave, and that will also lay out a little bit of the background to explain why it is that we're focused here today in these requests on reserve reports. So to do that real fast, and I think you all probably have a good idea of what reserve reports are, but I'm just going to point out here, this is from the SBE paper that we attached as part of our motion. Proved reserves, again, is the highest kind of standard. It's what the SEC requires. And of course, we understand that the San Andres isn't going to have proved reserves. There's no production from the San Andres. It's an ROZ. So, of course, we understand that's likely going to be the case, that there are none. But we're also looking for probable or possible reserves. And you'll see as I get into the testimony from Empire's Chief Operating Officer, why it is that we think that they may have done this. And if they haven't, that's fine. We'd like to know. So in any event, that's the basis for what probable reserves and proved reserves are. Now, this goes back to the Piazza case when we were initially seeking authority to inject in one of those wells that is subject to this subject set of hearings. It's the only case that's up on de novo appeal. Now, you'll see that I've outlined and highlighted some of the dialogue here between what the let me get to my point here. This is between Mr. Padilla and Empire's Chief Operating Officer. So where you see the A here for answer, that's their Chief Operating Officer responding to questions from Mr. Padilla. And I've highlighted his testimony. You'll see he goes on to say in response to a question that Empire has had their own subsurface team that has looked at the formations, are productive horizons. We've also had third-party studies that we've done, and that's what we're going. Those are the people I'm listening to on this one. So he's talking about that he's had third-party studies and he's had their own subsurface team evaluate formations with the EMSU. So, from my perspective, I think, okay, they've got internal studies and they've got third parties who are looking at this. Goes on to say that Goodnight is contending that Empire did not produce or is holding back documents and not disclosing those. Is that accurate? He says it's not. Of course, there are proprietary and trade secrets that are always at issue. We want to get those reviewed before, he goes on kind of to say, we want to make sure there's nothing proprietary. But of course, I wouldn't hold anything back from the court or from the commission. That's great. Okay. He goes on to say that Exxon did a lot of review. They did a lot of review of the RZ. So I hear this and I think, okay, ExxonMobil has done some substantive work on this, and I expect to get a lot of documents showing what ExxonMobil has done as the prior operator of the unit. He goes on to say that in response to a question, how do you view the ROZ potential in this field? We view it as a cornerstone of our strategy that we're going to appraise it at least. Okay. So my understanding based on this discussion and testimony, and it goes on, is that one of the reasons, the motivations for purchasing this unit is because they believe it has an ROZ potential. Okay. He says, now a project starts at appraisal, goes to select, define, and execute. So you see during this course of this testimony, he says we're in the appraisal stage right now. This is 2 years ago. We're appraising it. We feel comfortable that we're going to be able to have a very large production from across the whole interval, including the bottom interval, that'd be the San Andres. So he's telling me, actually telling Mr. Padilla in the course of his testimony that they have confidence that they have substantial hydrocarbons within the San Andres, that one of the reasons they purchased it was because of the ROZ potential down to the bottom of the San Andres. It's the cornerstone of their strategy. Now he goes on to say in the course of this dialogue, I have our own subsurface team and I've had other reviews say that there's plenty of potential on the order of basically company maker type potential that you would define as a residual oil zone. That's a substantial statement. I want to see what their internal reviews say about the company maker type potential. I want to see what these third parties reviews say about company maker potential. Okay. So this is important to me because during the course of this hearing, this is news to me. Okay. Does that include the San Andres formation? Does this company maker potential include the San Andres formation? His response, that includes the whole formation that we have unitized, the whole formation of the Grayberg, San Andres, which is our formation that's been unitized. Okay. So I'm hearing to myself, boy, they must have a lot of documents. They must have a lot of stuff that's going to show that the San Andres has potential, not only from them, but from Exxon, XTO, and from third parties that they've hired to review it. So at that time, okay, I thought to myself, well, we'll see what happens. The division ruled in the Piazza case that they went ahead and demonstrated sufficient evidence that there's at least potential for hydrocarbon recovery, so they denied our application to inject. Then we filed these additional cases in the unit, the four that are issued here, and I served them with discovery. Okay, number one, I want, based on everything I heard from Mr. Sweeney, I want documents, communications, correspondence, emails, analyses, reports, summaries, whatever you got, okay, that shows whether you believe there's hydrocarbons in the San Andres within the EMSU, but also documents that show that they're not. Okay, I don't want to just know what they're relying on to show that there are. I want to know evidence that is contrary or adverse to their position. This is it. This is a pretty simple, straightforward request for documents. Okay, I got 7 documents in response. I got 1 document that was prepared by Empire. The rest were prepared by Dr. Trentham and Mr. Melzer, or one involved Lithuanian ROZ potential. Nothing related to anything that he said in his testimony about the internal reviews they did, about the third parties they hired to evaluate the ROZ, or anything that showed that there's company maker type ROZ potential in the San Andres. I was a little disappointed that I didn't get what I asked for. Okay. What else did I ask for? Now, in the course of that testimony, if you were to review it all, you'll see that he talked about that Empire is in the appraisal stage. They're appraising the potential for ROZ. I had substantial dialogue with Mr. Sweeney at the time, trying to confirm whether or not Empire had prepared a written plan for how they're going to appraise the ROZ. He testified that, yes, we have a written plan. So I came back in the initial subpoena where I'm asking for documents. I asked him, and specifying directly to the testimony, please produce your plan. How are you going to assess and evaluate the ROZ in this zone? Eventually, I was told, that they don't have a written plan. Okay. They said they did, but they don't. And the written plan that Mr. Sweeney was referring to was an XTO brochure that was produced during the course of the hearing. That's what he meant, apparently. Okay. So that is all I got, was XTO's brochure that I understand was provided as part of the data room during the acquisition of the Empire EMSU unit when Empire was buying it. So in my mind, these three requests ought to have covered everything that Mr. Sweeney testified about at that hearing. I ought to have gotten their internal documents, their reviews and analyses showing that there is an ROZ potential, that there's company maker type productivity within San Andreas, but I didn't get it. Okay. So now I did have an ongoing discussion with Empire Council from about November until through, I don't know, man, March, back and forth. I was aggressive. I was pushing them. I wanted documents because they're claiming that there's an ROZ in this zone and they're seeking to completely extinguish Goodnight's operations. They've got 11 injection wells that they're disposing of, that they've authorized and approved within the area, and everyone but one, Empire is seeking to revoke. Goodnight has spent over several $100 million developing a pipeline system that brings in produced water. And of course, they take this very seriously. We have a right to this information and a right to see it. And apparently, whether they have it or not, we didn't get it. Okay. So that's the first round of discovery. And so, I'm not blaming, council for anything. I believe, whether Empire has this information, whether Mr. Sweeney was puffing about what they have or not, I don't know. But Empire has not produced what I understood them to have as far as development plans. Now, fast forward to today, okay, I thought to myself, well, they don't have any internal plans or development. Maybe they've done reserve reports. Maybe when they went to buy this cornerstone of their strategy in New Mexico, they would have gone and gotten a reserve report for their potential ROZ. Maybe it's not proved reserves, maybe it's probable or possible reserves, but I didn't get what I thought I would get with my first round, so maybe I'll try reserve reports. It has nothing to do with the financing of the unit. It actually is all to do with what data or information Empire provided to its third-party consultants who conducted or audited and gave their sign-off on whether or not there are hydrocarbon reserves in the San Andreas within the unit. So we served the current discovery that I'm discussing here today, which are these 7. And whether or not they have reserve reports or whether or not the communications around them is burdensome, I disagree. I think, we're at a point here where the issue, as we just laid out, is whether or not there's hydrocarbons in the San Andreas. And now, one other point I wanted to make is when this discovery issue came up, Empire had already filed its exhibits and testimony in the division cases. And that's when it became apparent to me that they had information potentially that went to our discovery requests in the first subpoena that that I believe was not provided to us. Okay. And the information that came through in their discovery, in their testimony, was information that Empire was relying on in support of their claim that there is ROZ. So again, we went through a process to get that information. I believe we now have all the information that at least Empire is relying on in support of its claims. But what I don't have is documents and information that show the non-existence of hydrocarbons, okay? Or, I think actually we do, because I think they actually provided it to us. But I also believe that there is a lot more information out there that they have that shows that there are no hydrocarbons in the San Andres. And that's one of the reasons why I'm now trying to get it through reserve reports. I want to see what data and information Empire provided to its third-party consultants to assess and evaluate the total reserves in the San Andres, whether it's proved reserves, probable reserves, or possible reserves, or even internal estimates of reserves, whatever it may be. I think we have a right to that information. I think the division would like to see that information. I think the commission would like to understand what is out there. And that's why I think these three requests are so important, and why I'm asking the commission to reconsider these three requests, because I think, we haven't been able to get to date what I think we are owed, and what the division is owed, and what the commission would want to see, which is, what is out there? What does the evidence actually show? And so I just, I think maybe my point was made, but I wanted to tell that story a little bit, because when you actually review the testimony from what Mr. Sweeney said, it was a very clear statement that they have these reviews, that they have these assessments, that they've gone to these third parties. And so I haven't gotten anything yet that shows that at all. Nothing. I have no internal reviews or assessments plans showing what they've done to undertake an evaluation or study of the San Andres. I've gotten slides and documents from Dr. Trentham and Mr. Melzer that are, public slideshows about, ROZ potential in carbonate, plays. But I haven't gotten anything internal that shows. Now, 2 years since Mr. Sweeney has said that they're undertaking an appraisal of the zone. And Empire's in the catbird seat. They are the operator of this unit. It's been there since 1984. They have hundreds of wells, lots of data. And it's maybe there's zero data that shows there's hydrocarbons in San Andres, fine. But I also want all the data and information that shows there's not. So with that, Mr. Chair and Commissioners, I respectfully ask that the Commission reconsider the denial of these three requests and move that Empire should be required to produce documents that are responsive to them, as well as the data and information underlying them. The data information underlying them is at least responsive to the first request that we asked for back last year. It's at least responsive to that, and we didn't get it, and we should get it here. And when you look at what, for example, the SEC filings and submissions, they look at, they review what was provided to them by Empire, okay? And while the SEC reserve report doesn't break down the location as between their North Dakota assets or New Mexico assets or any place else, the reserve estimates were based on interpretations of factual data furnished by Empire Petroleum Corporation. So that information is going to show, whether there are hydrocarbons or not hydrocarbons. And this third party did an assessment to determine, in their view, how many hydrocarbons there are and what the value of them is. Now, my point simply is that this is responsive. Like, what was provided to them is responsive. We didn't get it, as far as I know. So that's the reason for this request and the reason for this request for reconsideration. With that, I ask that our motion be granted and we be given the responsive documents, both to those three that were initially quashed and to the original request that we filed back last year.
Sorry.
Thank you, Mr. Chair. The three requests that Mr. Rankin is discussing are specific to reserve reports. Reports are by nature documents that are reported somewhere. They're not internal analysis, they are reports. And I've stated very clearly in our response to the motion that I filed late yesterday that we do not have reserve reports regarding hydrocarbons in the San Andres. We don't have them. The SEC requires reporting of proved reserves only, not possible reserves and not potential reserves. So for that reason, we do not have reserve reports that address whether there are hydrocarbons in the San Andres. Mr. Rankin's request really, it seems to me, is for the data underlying Empire's testimony and position that there are hydrocarbons in the San Andres more generally. And he is incorrect that we have not provided that information. I think Mr. Rankin is ignoring our first supplemental response to the subpoena and our second supplemental response to the subpoena. If the commission looks at our reply on our motion to quash, at page 21 of the PDF, we provided a copy of our second supplemental response to the subpoena. And Goodnight asked for all documents concerning the existence or non-existence of hydrocarbons in the San Andreas. We've supplemented that response. We provided an initial response. We've supplemented it twice. We provided publications, a fracture study, raster logs, another fracture study. We provided communications with our expert witnesses. We provided a restivity log, core analysis, core description, routine core analysis, a 1987 water flood report, a 1988 water flood plan report. So we have provided all of this information, and we've provided it again and again. And we are here again, listening to the same demands from Goodnight that we've been dealing with for months. And we have fully responded. Whether Mr. Rankin thinks our information is sufficient is his own issue, but we've provided all of the responsive information that we have to their request. So I just respectfully disagree. I don't think there is anything else that they're entitled to get. And I don't think the commission needs to reconsider its order. And Mr. Rankin previously asked specifically for the reports that Mr. Sweeney was referring to. We responded and said he's no longer an employee. We don't know exactly what reports he was referring to. But anyway, here are all the documents that we have. So that's where we are. We don't have anything else at this point in response to these requests. And I think the commission's order was appropriate and should be maintained, quashing the subpoena. We've provided all of the information that has been previously requested, and we are providing supplemental information in response to the request that the commission didn't quash. So I would ask that the motion be denied. And I'm sorry if I was speaking too fast.
No. I'll offer maybe a little insight because I was authorized by the commission at our last hearing to act on the subpoenas and the motion to quash. As explained in our motion or in our order, pull it up. Bear with me 1 second. And we had basically decided to quash those because we felt like it was pursuing that do not appear reasonably calculated to provide relevant discovery on the technical issues in this case, but on Empire's financial consideration for acquiring its working interest in the EMSU. Looking at the briefing on this question, and again, going back to the breadth of the request, I still see some facets of that conclusion. However, the couple of hours of discussions we had is one of the key issues for resolution at the hearing in September is the question of proved, probable, or possible reserves, which is in question 8, and at least the technical basis, it is in requests. Certainly 7 and 8, 9 still continues to me going to more financial questions as opposed to necessarily technical ones, but either reserve reports that might be filed or internal reserved estimates, proved, probable, or possible, and Goodnight's subpoena, at least into 8, did go beyond reserve reports. On reconsideration, at least in discussing it now, does seem to relate to a technical issue squarely up for decision in September. And so I guess I'd welcome a little bit more discussion on that observation after reading both Goodnight's filing and Empire's response.
Mr. Chair, it's a question to you, sir. Are you? Have I got this right? That slipped my mind. Never mind. I'll come back to it.
And I guess maybe I'd offer it up first to Empire, because it would seem to me that at least, internal or external documents or estimates, I mean, there are reports prepared for public consumption, and there are also reports prepared for internal consumption for different reasons. Relevant to prove probable or possible reserves seem to be squarely relevant to the issues we're going to be deciding in September.
And Mr. Chair, I think the issue, right, is whether there are hydrocarbons in the San Andreas within the EMSU, right? So if the request pertained to reserve reports prepared regarding, or supporting documents for those reports regarding the existence of hydrocarbons in the San Andreas within the EMSU, we don't have them because those are not reported. And if you look at the SEC reports that Mr. Rankin is showing, they are combined geographic areas, combined formations. They don't relate to those issues. So I think that's the problem. And the other issue is that reserve reports that are publicly filed with the SEC are for, of course, a different purpose, right? I mean, the Commission and Division's obligation is to protect correlative rights and prevent waste. The SEC has very strict parameters on what they require reporting on because they're looking at it for a different purpose. They're looking at it for whether people should invest in companies or not, right? So it's just a different purpose. But I think the bottom line, and I've said this in our